All right, good afternoon, everyone, and welcome to CCI Haronia's May Lunch and Learn webinar. Today, our Lunch and Learn is entitled Condo Catch Up, and don't worry, we are not talking about the stuff we put on our fries, hot dogs, and hamburgers. We're going to catch you up on some condo-related issues that, despite all the chaos of COVID, we still feel that these are things that you in condo land need to know about. So, good afternoon. My name is Sonia Hodis. I'm one of the many directors at CCI Haronia. I'm a condo lawyer as well as your moderator today. If you thought you missed our April Lunch and Learn webinar, don't worry. We didn't have one. We actually took a break last month on the Lunch and Learns, and instead we did a 2-day intensive director's course, which was a huge success. This is the first time we did it online, and we had almost 60 people attend. We had great participants and great speakers, so if you missed out on it in April, you definitely want to make sure that you catch us the next time we hold it. As I said, today we're going to focus on bringing you up to speed on various issues that affect condos. Some of them are COVID related, but many of them are not. Although not much has changed since we did our last COVID webinar update in January, there's a couple of things just to note. The government has extended to December 31st of this year the ability for condos to hold virtual meetings and do electronic voting without a bylaw. So if you haven't passed a bylaw yet, you still have some time to do so, and you can continue to hold your meetings virtually without it. We're back in a lockdown, and a state of emergency has been declared until June 2nd now, which started just after the Easter weekend. We've all been here before and probably likely will be here again sometime before this is all over. But many of the issues that we're facing now in this lockdown are issues that we faced previously. And I just want to remind everyone that CCI Haronia has done a bunch of COVID-related webinars over the last year and a half. And you can get access to all of those webinars on our website, cciharonia.com. If you just click on the events tab and past webinars, you'll see the list of webinars there. So if you've got some issues that are coming up because of this lockdown, you might want to check out some of our past webinars. You may find some answers there for you. In addition, the government restrictions for the current lockdown can be found on the government website, covid-19.ontario.ca. And in terms of restrictions, one of the really important ones for condos is that we cannot hold in-person meetings at this time, and most, if not all of our amenities are closed. We're not in the rainbow plan right now. We're all in the same color zone, and the government has no idea if we're going to be returning back to that rainbow plan and staggered rules throughout the province. Vaccinations are rolling out, and this raises a bunch of new issues for condos, and one of our speakers is going to be talking about that today. However, despite COVID-19, condo land continues to operate, and there are issues that continue to rise that are not COVID related, and we need to deal with them. So that's what today is going to be focused on. We've got a great lineup of speakers who are going to catch you up on what you need to know. But before we start with our speakers, as always, we want to make sure that we thank our sponsors. If you've been to any of our webinars before, you know that without our sponsors, we're not able to offer these webinars free of charge. So thank you to our sponsors, Bayshore Property Management, Integrity Property Management, FCS Fire Consulting Services, and Common Ground Condo Law. So thank you to all of our sponsors. And in case this is the first time you're with us, let us just tell you about who CCI is. CCI is the Canadian Condominium Institute. We are an independent, nonprofit organization formed in 1982. We have chapters across the country, and in Ontario, we have 8 chapters alone. CCI Haronia is one of those Ontario chapters, and we are the current winner of the Lorne Young Chapter of the Year Award for Tier 1. CCI's main objective is education, and CCI also advocates for condos. We represent all those involved in condos, from owners to directors to professionals, and we encourage all of these stakeholders to work together. If you're not a member of CCI and you would like to enjoy the benefits of membership, feel free to join one of your local chapters, and Debbie Dale, who's our president, is going to put some information in the chat box about how you can find out about chapters near you. In addition, CCI National has a resource center with a great deal of information available for you to search. There are COVID-related issues, but a lot of other issues that affect condos. You can find information in the resource center about those. You can go directly to the national website, cci.ca, to access the National Resource Center, or you can just come to our website at ccihuronia.com and click under Resource Center to get access to the National Resource Center from our website. It's a great resource for a collection of information from across the country and from our various chapters coast to coast. And don't forget to like CCI Huronia on Facebook. Great place to find out about our upcoming events, as well as our website, ccihuronia.com. And if you haven't checked out our new newsletter called Condo Buzz, be sure to do so. You can access that on our website. So just a couple of reminders. If everybody can make sure that you just keep your phones or your devices muted during the webinar. We are recording this webinar so that it's available for future viewing. So if you could just keep everything muted unless you're a speaker, that way we can get a good recording for people in the future to look at. Also, this is being recorded, so if you're not a speaker, you may want to shut off your video. And if you're having any trouble with connections, just log off and log back in again with the connection details that you received by email. And if you're still having trouble on your computer or tablet, you can always just dial in by phone, and there is a phone number available in the information that you received by email. We will try to take live questions at the end if we have time. We do have a very jam-packed schedule today, so we will try to take live questions, but feel free to put your questions in the chat box. You can find the chat box button on the bottom of your screen. It looks like a little bubble. If you put your questions in there, the speakers are going to try their best to answer those questions throughout the session. And if you're dialing in by phone, you can always raise your hand at the end during the live question and answer period by pressing *9. And finally, before we get started, the information that you're being provided today is general information. It may not apply to your specific fact situation. If you're a condo director and you want to use the protection of Section 37 of the Condominium Act, you need to get an opinion about your specific fact situation from your own professionals. This webinar is not intended to provide you with opinions that would protect you under Section 37 of the Act. And because this webinar is being recorded, I just want to make sure that everybody understands, if they're watching this later, the information provided is current as of May 14th, 2021, and things change rapidly, so the information today may not be relevant down the road, so just be aware of the date of this webinar. Also, any references to legislation are references to Ontario legislation. So let's get started with our first speaker, and we've got Patricia Leah, who is going to start us off with talking about vaccine passports and mask policies. She's going to look at this from the court's view. So Patricia, take us away.
All right. Thanks very much, Sonia. And thanks everybody for being here with us. I know we have a packed agenda, so I'm just going to jump right into it. So COVID or vaccine passports, are they a good idea? I was just recently reading an article in The Economist, and we're going to provide you with a copy of that link in our chat. So you can see from a science and technology perspective some of the world views on vaccine passports, because you're hearing about it all around you. So it made me wonder, is it a viable option for condominiums? And my conclusion is it really doesn't make sense at this time. Why? Well, we have enough to do as a condominium generally, but when you really look at the underlying parameters around vaccine passports, what they're trying to do is manage people coming in and out. And practically speaking, in a condominium, you're not really going to be able to control people so much when they go out into the real world, to the grocery store, etc. And ultimately, the question is, why would you have it, and what would you do with that data? You know, the first thing that comes to mind is, well, you can't stop somebody from coming back into their unit. Even if they have COVID, you have to manage around it because it's their home. So it's not going to be a way of actually managing people from staying off the premises. As well, if you think about the logic underneath vaccines, vaccines offer protection from the virus that causes COVID-19, but it's not clear if they significantly cut transmission. Therefore, all it's telling you really is that you've been vaccinated and that you will not get sick. It doesn't confirm that you won't spread it. So we also have to make sure that we don't give these passports more validation than what they really can do. Another risk, of course, is privacy, security of personal information. Under the Condominium Act, Section 55, we are not allowed to share personal information. However, in a pandemic, and we've all experienced, we have an interesting balance of trying to keep our communities informed. If somebody gets an exemption, for example, to wear a mask, that presents a risk to the people in the community, and that has to be managed through communication. But it should be done on an anonymous basis. It might be self-evident that there's an exemption, no doubt, when you're walking down the hall and you question why somebody doesn't have a mask. But at the same time, we're not here to spread that information. If somebody gets COVID, again, we're not disclosing who got COVID, but we may want to inform people of the fact that we are managing a case in the community. All right. So that is where we need to balance privacy and our responsibilities to our community. And I'm going to talk a little bit more about this as I get into the cases, because there are a few cases that we need to consider. So I think right now, from the perspective of should we have passports, they're not going to be effective because, as well, the last component to think about is the fact that not everybody is immunized or has the opportunity to be immunized. And so you're going to create this unfairness because of access to vaccines. So until we have more of the opportunity for herd immunity, we know exactly what the parameters will be. It's kind of a premature discussion. So let me just jump into cases. There are 3 cases: Toronto Standard Condominium Corporation 1704 in Fraser, Halton Condominium Corporation number 77 and Mitrovic, and Carlton Condominium Corporation number 32 and Yakolev. Pardon me. So we've talked to you a little bit before about Fraser, and that is a case where the board put in place a policy during COVID times to address renovations. The court found that the corporation's policy was valid and enforceable, and that they actually had enforced it. The court found that the policy was reasonable, could be enforced, was being enforced, and that it was a reasonable exercise of rule-making powers. They did not treat Mr. Fraser unfairly, prejudicially, or in an unreasonable manner. The repair work that was proposed by the unit owner was not deemed to be an emergency that required immediate repair. So this is the first case where we actually have the courts recognizing the balance and the need to address the pandemic. So that case, I thought, was a very good outcome for condominiums. Why? Because it actually reinforced the independence of the fourth level of government, which is really what we see condominiums being. The next case, HCC 77 in Mitrovic. 2 owners at HCC 74 were refusing to wear a mask while on the interior common elements of the condominium corporation, despite the condominium having a mandatory mask policy in place. The condo commenced a court application. The respondents claimed to be exempted on the basis of their unspecified medical conditions. The condominium mask policy required residents to wear masks while on the interior common elements, subject to exemptions for children under 2 years of age, persons with an underlying medical condition which inhibits their ability to wear a mask, persons who are unable to place or remove a mask without assistance, and persons who are reasonably in need to be accommodated in accordance with the Ontario Human Rights Code. Sounds like all reasonable parameters from my perspective. So there was evidence of these parties not wearing their mask, and the question before the court was, can a condominium have a mandatory mask policy in place? If so, can it enforce the same? And do the owners have to produce medical evidence to support their claim that they have a medical condition? In an interesting sort of holding, and I'll tell you why I thought it was interesting, the court made an order limiting where the owners could go in the building, and that should they continue to refuse to wear a mask. The court declared that exercising or visiting any other floors in the building other than the ones where their unit was located without a mask constitutes a dangerous activity in breach of Section 117 of the Act, which is a critical standard in the Act, which is the corporation can't allow a dangerous condition to exist in the corporation. So this is why it was interesting, is that the court allowed the wearing of masks, wearing of no mask in certain areas. which left me with the question is, okay, so how did this happen? Because the court did recognize the global pandemic, did understand that, Burlington's municipal bylaw had parameters that you had to wear a mask unless you had a reason not to. And there was no actual specific medical evidence produced to show this medical condition. As well, what it did was it acknowledged that this is a dangerous condition on other floors of the condo, and those unit owners do not have to be exposed. But the people on the same floor as these individuals have, it's not a danger. It seems to conclude that it's not a dangerous condition on those floors, which actually doesn't really correlate to the scientific evidence on how the virus is transmitted. So to me, it seemed like an inconsistent finding for a couple of reasons. Why? Because the corporation's right to ensure its own policies and procedures within its own private structure were not upheld. And an exception was carved out, but not based on scientific reasoning. Final case, CCC number 32 and Yakovlev found that CCC 32 applied on an urgent basis for an order requiring the respondents to cease and desist from engaging in conduct that CCC 32 says contravenes the Act, the corporation's governing documents, and the City of Ottawa's temporary mandatory mask bylaw. CCC 32 indicated that the respondents had created excessive and unbearable noise and engaged in aggressive and harassing behaviors towards others and failed to comply with the mask wearing requirement. So there were a bunch of allegations here. And they maintained, the respondents said that they have been harassed and there was, a back and forth, and they had a position basically to justify their behavior. And here's what the court did. The courts found that the respondents, by their conduct, had breached the Act, the governing documents, and the mask bylaw. So there was a bylaw here from the city. And the court issued a compliance order requiring that respondents comply with the Act, the corporation's governing documents, and the mask bylaw. So the court covered everything in one fell swoop, with the opportunity for CCC 32 to seek a forced sale of the respondent's unit on the filing of affidavit evidence confirming further breaches. So the court went the full distance to say, and if you can't comply with what we set as the parameters for our community, we can actually make sure that you are forced next time to sell your unit. And we're not going to be coming back to court. We're not doing this again. That's it. That's the threshold. So, to me, the court said that the corporation had a duty to take all reasonable steps to ensure owners and occupants complied with the Condominium Act, the corporation's governing documents, and applicable laws, and it had a duty to ensure that no unsafe condition or activity that is likely to cause harm to persons or property is permitted to continue. So, short story, court upheld the corporation's direction around mask enforcement. Like, this is the really key thing here, based on the evidence that supports the fact that mask wearing on the common elements is something that is actually being directed. It highlights an issue because at the provincial level, the legislation says you don't have to prove that you don't need to wear a mask. But at the same time, how does that translate to a condominium corporation that has an obligation to its employees, to other owners? Why is it that the people on the floor with the non-mask wearers, their lives are really not as invaluable as the other people on the other floor, when it's being acknowledged that it is a dangerous condition? So now we're creating inconsistencies. I really don't think that the second case I presented really is, unfortunately, I don't think it was really the right outcome here, especially based on the limited evidence of really any medical evidence. So just so you know, there are conflicting cases out there, but really you should follow a logical set of circumstances and evidence to support how you bring into place your corporate governance. And, at the end of the day, you may have to fight for compliance. You may have to do the court application based on the facts, but you should have all the evidence in place to show what the corporation's position was.
Thanks, Patricia.
You're welcome.
All right. So, I mean, this is a discussion we could go on for a long time, but we don't have a lot of time. Courts don't always get it right. I definitely think that Burlington case, the whole analysis around human rights did not get addressed at all, and
Mhm.
that's maybe why we have an absurd result. But I'm going to talk today about rules versus policies, because we do have a decision from CAT, which is the Condominium Authority Tribunal, on this issue of rules versus policies, and what are you supposed to do, and when do you use a rule, and when can you use a policy. And I think it's really important to just highlight this because it applies not just to the mask policies or the renovation policies during the pandemic, it applies to policies generally. And I think it's a good, I don't always agree with CAT and what they come up with, but I think this decision actually is not too bad in terms of setting the framework. And so the case is called Boudram versus Peel Standard Corp. Condo 843. And if you remember back to sort of, condo basics, we have a governance framework in which we have a hierarchy of documents that starts with the act at the top, then the declaration, then the bylaws, then the rules. And policies, they're not mentioned in the act. They're still part of the governing documents of condos, because some condos do have policies, some condos have lots of policies. But they're not actually mentioned in the act. And that's a really important distinction between the declaration, bylaws, and rules versus policies. And it's important to distinguish that, because if there's no mention in the act about policies, there's also no enforcement mechanism in the act to enforce policies. And so what the Boudram case highlights is that it's okay to have policies to set out procedures, but it's not okay to have policies to create an obligation that doesn't exist in another governing document, such as the declaration, bylaws, or rules, or such as the act. So if we go to our mask policies or our renovation policies during COVID, those obligations come from the act itself, because, as Patricia said, the Condo Corporation has a duty to make sure that the premises are safe, and Section 117 of the act doesn't allow dangerous activities to occur on the premises. And so there is an obligation that exists somewhere else. If we look at some of the other policies that condo corporations may have, you may have a human rights policy, harassment policy. And again, the obligations for an owner to do or not do something arise outside of that policy. The policy is really setting the position of the corporation and how they're going to handle those types of issues. So in Boudram, what the condo did wrong in Boudram was they tried to rely on obligations that were set out in a policy, but were not contained in the rules themselves. So this was all about visitors parking. And in the declaration, there was a provision that said visitors parking is only for visitors. So if you're an owner, you can't park in visitors parking. If you're a resident, you can't park in visitors parking. And then the corporation also relied on a policy that said you had to get a visitor parking permit and that you were only allowed 8 of these permits a year. Now, there was a resident who had someone who she claimed was a visitor, who the corporation thought was a resident, and started issuing tickets against this vehicle. And so the owner took the corporation to CAT to get a determination as to whether they were a visitor or not, and whether these tickets were valid. Now, aside from the policy issue, there was also an evidentiary issue about proving whether this person was a visitor or not, and I'm not going to touch on that. But on the policy part, the tribunal made it very, very clear that policies are okay. Condo corps can have policies, but you definitely need to make sure that they're not creating an obligation. So what's the lesson that we learned from Boudram? Don't rely on policies to enforce an obligation that doesn't already exist in the act itself, in your declaration, in your bylaw, in your rules. Don't use the simple policy creation procedure, which just requires a board resolution to pass a policy. Don't use that simple procedure to avoid the procedures under Section 58, which require notice to owners when you implement a rule. Don't try to bystep that to try and create some new obligations, because if they are challenged, there's a good chance that they're not going to be held up. So if you're creating an obligation, you need to give at least owners the notice under Section 58 and put it in a rule, and leave your policies just to procedures. So let's move on to our next speaker. And we have Raleigh Metchler from Elevator One, who is going to give us an update on what's happening with the elevator legislation. So Raleigh?
Anya, thanks so much. And it's nice to see everyone virtually. I really look forward to when we can meet in person again, though. So there was a presentation yesterday by the Ministry of Government and Consumer Services, and it was about a 90-minute presentation, and I believe a number of the people on this call attended that. So I'd love to hear your feedback in the chat section, what you thought of it. I've heard only good things. They talked about roles and responsibilities of different participants, overview of elevator maintenance contracts, tips to supporting a good relationship with your contractor. It all began with there was a number of issues in Toronto a few years back. You may have heard of it on the news. The Court Justice Douglas Cunningham released a report, and part of that said there was a lack of public education. So that's the reason they came up with this presentation yesterday with the input of different stakeholders. And I saw that CCI was one of those. We also contributed to that, and they gave credit to both parties, which was nice. And again, their goal was to provide elevator owners and managers with information that ultimately improve elevator availability. And they talked about different things that impact that. And it's not just, poor maintenance. It can be damage from floods, insurance adjusters getting involved, approval of getting work orders done. Sometimes that's on the part of the owners not approving those, availability of parts, mechanic availability, rider misuse. So there's lots of different reasons that there's challenges with availability. Then they talked about all the key parties. There's a lot that are involved. There's the Ministry of Government and Consumer Services, and they're actually the ones that give the power to the TSSA. There's the contractors, the mechanics, consultants, municipalities sometimes get involved, manufacturers, owners, and elevator users. So there's lots of folks involved. When they presented and talked about owner responsibilities, there was one new one that surprised me. I didn't know it was coming. And it's reporting elevator outages of 48 hours or longer and associated information to the TSSA. There was a little asterisk beside it. That's as of July 1st, 2022. So we've got some time, and it does say that the TSSA will engage stakeholders on the implementations of those. So nothing you really have to worry about now other than knowing it's coming, and we will certainly find out about it. And if CCI isn't one of those stakeholders, we'll make sure that they are, because you'll definitely want to have some input into what that looks like. They talked about maintenance then, and they reminded everyone that the Elevating Devices Act prohibits maintenance visits greater than 3 months. So you can't have a gap of greater than 3 months in terms of your maintenance. I'm going to share a document real quick right now that they shared as well, and it talks about sort of the reasoning for that, and one of the advantages of making sure that you're getting constant maintenance. And it shows that if there's a gap, i.e., the more preventative maintenance you're getting, the longer the life service of your elevator. And it seems it's pretty intuitive, but there's something to that. So if you're not getting the regular maintenance that's required on your elevator, you may be saving money up front, but in the long run, it's going to affect you.
And Raleigh, I'm just sharing the screen of the document that you put up in the chat box that people
Awesome.
can link on. And this is the document that Raleigh's referring to if you just click the link in the chat.
Thank you so much. Then they talked about logbooks. So these are the books that a mechanic would use to show that they've done the required maintenance. And they show that it's actually an owner and a contractor responsibility. So, and we often mention that in our lunch and learns. Make sure you look at the logbook to find out if your maintenance is being done. They then went on to talk about repairs and modernizations, about full modernizations that can cost anywhere to $100,000 to $200,000, and typically done every 10 to 25 years. We talked about component upgrades. They also then talked about what impacts the price of your contracts, things like age of equipment, frequency of maintenance, location of buildings, etc. And then they talked about the type of service level. And again, I'm going to try to share something real quick. I'm not sure if I didn't press it last time. I'm sending it to everyone this time, so let me try again here. Excuse me. This one's really important. as you'll see here. When talking about price, Sonia, were you able to see that? Did that come up for
Yeah.
everyone?
Is
It
this the
did.
Mona
Oh,
Lisa one?
the Mona Lisa, exactly. That's just so
Okay.
important, right?
I am going to share that so everybody can see it. You can continue talking and I'll share it.
Yeah, so often we hear, your price is too high. And I say, well, have you done a fair comparison? Because often it's not just the initial price that counts. And then they listed a whole bunch of questions to ask your contractor before deciding are they the right ones. Things like what's your geographic area? How many mechanics do you have? What's your familiarity with equipment, et cetera, et cetera. So again, I'm going to make sure that there's a link within the next 5 days. They're going to provide a link to the presentation that was done. And if you didn't attend yourself, I really suggest that you or at least somebody from your condo board look at the presentation when you get a link to it and just go through it, because there's really invaluable information that's there. Again, just allowing you to make sure you've got a good relationship with your elevator contractor, that you're asking the right, signing a contract, and then knowing about things like um, elevator availability through this time and things that you can do. They mentioned things like making sure your door sills are clean, wiping clean, providing proper air conditioning in machine rooms, maintaining documentation on what's going on, giving information to elevator technicians so they can help solve your problems, and then just other advice in supporting a good relationship with your elevator contractor. So really, those were the highlights. There was obviously a lot more in a 90-minute presentation, but I thought that would give you some highlights of what was there, maybe get you excited to listen to the presentation yourself when the link comes out.
Great, thanks, Raleigh, and thanks for bringing that to our attention, because we were able to then e-blast that information out to all of our members and non-members on our email list. So if you're not on our email list, send an email to admin@ccihuronia.com. Ask to be put on our email list. That's how you get all this information that we share through our webinars and information that we receive and we pass on. And Raleigh, once you get that link, if you send it to me, I'll make sure that we get that e-blasted out to our email list, and people can then go watch the webinar when they get a chance. So thanks again, Raleigh.
Will do. My pleasure. Thanks, Sonia.
So from elevators to electric cars and charging stations, we have Laura Bryson with us today. Laura, what is going on? I know there's a deadline coming up with respect to some funding when it comes to electric vehicles and charging stations.
That's right. Thanks for having me today, Sonia. And hi, everyone. It's great to be here. I wanted to talk first about the process of installing EV charging infrastructure and what to look out for in your condos. And then second, I'll talk about the EV charging funding that Sonia mentioned, which covers 50% of project costs and is available until June 22nd. So the EV charging journey in a given condo usually starts with that first or second request from a resident that just bought their first EV or they're considering buying an EV, and their home is the most convenient place to charge it. So we really think of EV charging as a multi-step process, starting with gauging the demand among your residents. So this can start with a survey. There's templates that are out there to help you gauge that demand and get a sense for whether you might go down a private charging route where you install or residents opt to install their own private charger in their personal parking spot, or putting in a set of shared community chargers that can be accessed by all residents, or potentially a combination of both, which we do see in some condos. But the key thing to think about as you're surveying your residents is, how do we make this cost effective and scalable? How do we ensure that we can satisfy the charging needs of not just that first or second resident, but more residents down the road? And the next step would really to be think about your service provider. What's your service provider going to look like, and what are the technology options? Your service provider would be responsible for doing a site visit, for helping you think through the different technology options. For example, these electric vehicle chargers, they do consume more energy than some appliances. So you want to think about how you're going to meter and bill for that energy. And you're also going to want to think about the energy management component. So in your building, the existing electrical infrastructure, it's really the limiting factor. And especially in older buildings that have outdated infrastructure, one of the biggest costs can be just getting that new electrical infrastructure in there. And as you're thinking about which path you want to go down, you can also start thinking about the cost sharing. So how will residents contribute to the financial component of installing charging infrastructure? A popular model that we see for private charging is where the residents will essentially contribute a certain portion of that, let's say a dedicated EV panel, as well as getting the power to their personal parking spot and for their own personal charger. Once you've reviewed the proposal and you've decided you're ready to move forward, then your service provider would also be responsible for getting the charging station in safely, that it meets local electrical safety codes, and that it's managed on an ongoing basis. So one question that I would encourage you to ask a potential service provider is, is the service automated? Is it something that is hands-off for the board, for the property manager, and for the residents? And how will that scale over time as demand for charging grows? And then the other piece that I wanted to focus on is the federal funding. There is an opportunity right now at the federal level through, it's called ZEVEP, Zero Emission Vehicle Infrastructure Program. And it's administered by Natural Resources Canada. It's offering 50% off of all project costs, including electrical infrastructure, installation, engineered load reviews, and even the charging stations themselves, up to $5,000 per level 2 charging station. And it is applicable for both retrofits and new construction buildings, and also for private or community charging stations. So a good example of an electrical contractor that we work with, they put in a lot of electrical infrastructure, and now they're going back to their properties and saying, okay, these residents, you're ready to put in your own private charger. We can now do that through this program. One of the requirements to be aware of with the program is there is a minimum of 20 charging stations that need to be installed, but I wouldn't let that intimidate you, because it can be split between multiple properties or multiple sites. And the government does encourage collaboration with other organizations. So as an example, my company applied last year and submitted for several properties, both retrofit and new construction, and we installed anywhere from 1 charger per site up to 40 chargers per site. So there is some flexibility in meeting those requirements. And with the deadline coming up, and as I pointed out, it is a bit of a long process, that you want to be thinking about how to set up a policy that makes sense for your building longer term, and set yourself up to take advantage of the rebate while it's available.
Thanks, Laura. And what's that deadline again?
It's June 22nd.
Of 2021.
2021, yeah.
Okay.
And it is a program that's opened up multiple years. It was funded initially in the 2019 budget and was topped up in 2020. So there's a possibility it will be around next year as well. It's TBD, because it's evolved and changed quite a bit between the years.
All right. And if anybody has any specific questions for Laura about this, you can put it in the chat box, and you can also look at the chat box. There is her contact information there if you want to reach out to Laura directly. So thanks, Laura, for coming in, letting us know about this potential funding. And although the timeline is tight, it's still open and available. All right, so we're going to move on now to Cheryl Wood, who is a lawyer from Ottawa. And Cheryl, you're going to talk to us about something that seems to be very new to the market, service line warranties. What is it? Who does it apply to? Should we get them?
Yes, thanks, Sonia, and good afternoon, everyone. So as Sonia mentioned, I'm going to be speaking about the Service Line Warranties of Canada. And it's a new issue that's come up in the Ottawa area, but it's relevant, in my view, to condominiums across Ontario. So I'm going to touch on how it came up in Ottawa, a little bit about the warranty, and then I'm going to go into things that you should be considering for your condominium corporation, even if the warranty hasn't made it to your area yet. So in the last couple of months, property owners, including condominium owners in Ottawa, have received a notice. It appears to come from the City of Ottawa, but it's actually from Service Line Warranties of Canada. So I'm just going to see if I can share my screen quickly so that you can see what this notice looked like. So I think it should be up there now. And the city logo is up there on the top of the notice, and it says the City of Ottawa at the bottom, and then in the fine print it confirms that it's from Service Line Warranties of Canada, and they didn't get your information from the city. So that's the notice that came up, and it caused quite a stir because of the confusion of who it was coming from and what these warranties do. So I also note that Service Line Warranties of Canada has partnered with some other municipalities in Ontario. A couple of examples are Port Hope, South Huron, Kingston, Kincardine. So they are starting to come up. I know Kingston was 2019, so over the last couple of years they've been building throughout Ontario. So if your municipality hasn't partnered with them already, they might. The warranty that's sent out, it's a warranty plan, and it's where you pay monthly, monthly, quarterly, or annually to cover a failure in the service lines. And these are the service lines that run between the road, essentially the road and your property. In the letter, in my letter that I received, it confirmed that the cost for me would be $127 a year, and that would cover me per incident up to $8,000 for certain service lines and $16,000 for others. And these are water service lines and then sewer service lines as well. And then in this, I had one other picture I can show you that came in the package, and it shows you where the property boundary is. This would all be municipal, and then in the black is the water service line, sewer service line, and storm water sewer service line that would be the homeowner's responsibility. Okay, so what does this mean for your condominium corporation? These notices appear to have two purposes. One is to let the property owners know that these service lines are your responsibility. So it flags that for property owners. For condominium corporations, these service lines can, in many cases, form a part of the common elements that would be repaired and maintained by the condominium corporation. And that's unless some other party, such as the city or a neighboring property, has a responsibility under terms of easements or another instrument. So for the condominium, in all parts of Ontario, the repair and maintenance of these service lines are likely the responsibility of the condominium. Second, the notice also lets property owners know about this Service Line Warranties of Canada program and offers them a monthly, quarterly, or annual fee to cover the cost of these and help lower the burden of any sudden significant costs that you would face when you're repairing these. Does it make sense to purchase the offered warranty plan? In some cases, it might in fact be a good idea, but there are a number of factors to consider. Now, for time purposes, I'm going to go over a few of the factors or questions that I think condominium corporations should turn their mind to. We have prepared a blog on this issue as well, and I'll put a link to that in the chat box after I'm done. So some of the questions, I think, are these service lines covered in your reserve fund plan right now? what are the service lines in question on your property, and including the materials, length, and size. Are you sure that those service lines are your responsibility? Is there anything that sets out that someone else might have responsibility for these lines? What are the age of the particular service lines? It might not be as big of an issue for a new build, but for some older condominium corporations, that these pipes might be coming to the end of their life. It might be something worthwhile to consider. So these are all questions that I think could be put to your condominium corporation's reserve fund analyst or engineer. And then when looking at the warranty, a couple of questions is, what exactly is covered by the warranty plan? Are there any exclusions that you should be aware of? And could the corporation have or purchase coverage for this work from another company, or could the coverage be obtained in another way at a lower cost? So in my view, just in summary, I think the key takeaway from this issue that's come up and these notices that owners in Ottawa have been receiving is, how is your condominium corporation, wherever you are in Ontario, planning for the repair and replacement of service lines right now? And would a warranty plan in the type being offered help reduce costs or funds that need to be contributed to the reserve fund? And I think that these are fantastic questions that you can put to your reserve fund analyst or engineer when you're considering these things.
Thanks, Cheryl, and thanks for, it seems like in the eastern part of the province, this is starting to roll out, so it's nice to give sort of everybody a heads up warning of what may be coming in their mailbox soon. So thanks for sharing.
No
All
problem.
right. So moving on, our next topic is Bill 118 and the Occupiers Liability Act changes that were came into force last year but implemented this year. And so Tricia Barata is going to talk to us about these changes and how it impacts our claims. Tricia?
Great, thanks. Thanks for that, Sonia. Okay, so yes, as you said, Bill 118 was passed in 2020, came into effect January 29th, 2021, so still pretty new. It affects the notice requirements for someone wanting to pursue a claim against an occupier for injuries resulting from a slip and fall related to snow and ice. So the occupier, as we know, being the condominium corporation for the purposes of the Occupiers Liability Act. So the requirements previously, they allowed for 2 full years for a claimant to come forward with allegations of injuries and looking for damages associated with that. So what Bill 118 does is it makes changes that allow the claimant to only have 60 days to do this. So the claimant is required now to provide written notice to the corporation or to the contractor that's servicing the property for the purposes of snow or ice removal. It has to be in writing. It has to be hand-served or sent by registered mail to the corporation. And it must include the date, the time, and the location of the injury or the alleged injury. And it must, as I said, be provided within 60 days of the event. Significant change, significant in that 2 years for a claimant to be able to come back at the corporation with allegations of injury related to the property, down to 60 days. So this is an enormous change. So if the claimant doesn't provide this new written notice requirement within the designated time period, the corporation is likely to be able to just have the suit tossed out. There are a couple of exemptions, however. So if the injury does result in death, or if the judge finds there's reasonable excuse for the notice period not to have been met. And that the defendant is not prejudiced, so the corporation isn't prejudiced in its ability. So, I mean, if someone is hurt and they're in the hospital longer than 2 months, they may not be able to provide the notice within the period, and therefore there's an exception there. So how it affects condos, well, it's definitely going to affect claims. So we see our clients have notice of claims show up a year and a half, almost 2 years to the day of when an alleged slip and fall has taken place. What is a condo to do when they get this notification almost 2 years after the alleged occurrence? Evidence, it's very difficult to go back in time for 2 years. You can't, to go look at that location, that area that the alleged occurrence took place. So evidence is definitely going to be easier here. It's going to be easier to see that location and likely in the same condition as it was even 60 days ago, rather than 2 years. And witness memories are so much clearer within 60 days than 2 years. So very, very good for the nuisance claims, the claims that, someone alleging something that may or may not have actually occurred, or the condominium corporation to be able to go back and get that evidence in place to defend themselves. Fewer claims is going to be crucial to the condominium corporation's premiums, their insurance premiums. So costs related with making all these claims definitely means that the insurance premiums are going to go up, and that affects every single unit owner. Especially in this hard market, we don't want claims, absolutely no claims if possible. But the other way it helps the condo corporation is it allows the corporation to immediately take steps to rectify anything that might be wrong on the property, so they can prevent any future injuries or losses or claims. The benefits to the contractor too. So the contractor is going to see many less nuisance claims related to slips and falls, alleged slips and falls, with this shorter time period. Their insurance premiums can decrease with fewer claims, and that is immediately going to translate to the condo corporation and each unit owner in the services being less expensive because the overhead is less expensive, and therefore the condo corporation's condo fees, each unit's condo fees will likely be affected as well.
Thanks, Tricia. So it sounds like this is good news not only for the service providers who are providing snow and ice removal, but also for condos as well in terms of the long run. I guess one thing, though, condos should be careful is don't destroy records after 60 days just because 60 days has passed, because there are some exceptions there to that 60-day rule. So you want to make sure you're still keeping that documentation for the long term, just in case that case slips through on one of those exceptions.
You got it. Thanks, Sonia.
Thanks, Trish. All right. So talking about maintenance, and let's move on to our next topic. And we've got John Jeffs, who's going to talk to us about maintenance and repairs. And this is kind of a COVID-related topic because we've been hearing, sort of since the pandemic sort of got into full force, we've been hearing about these shortages of labor, shortages of material, rising costs. So John, is this a myth or reality, and what's happening in terms of COVID and obstacles to repair and maintenance?
Thank you very much, Sonia, and good afternoon, everyone. So yeah, there certainly is a reality to increased costs, particularly on some materials. We've gotten notice of several roofing manufacturers have increased their material supplies by as much as 15%. We all know the story of getting lumber, and deck and fence work has just simply been put on hold or eliminated, except in the most dire of circumstances. So those things are definitely reality, and they are adversely impacting the costs of doing work and so on. But thankfully, I mean, from our perspective at McIntosh Perry, we've tendered a number of projects over the last year and a half with all sorts of trepidation as, could we even get the job done? Was it really essential? And so on. And I highlighted 4 today, 2 garages, 2 garages, 1 roof, and 1 parking area that doesn't have a garage beneath it. And we had, as we usually do, we had put in what our estimate was, and we often find our estimates are lacking or, overlap. But I chose these 4 because in 3 out of the 4 cases, our estimates were actually too high, or the market was so competitive that a number of bidders were able to come in. So 1 garage tender, we were expecting to come in the 3 to 3.5 million. All tenders came in the range from 2.6 to 3.1 million, below, just at or below our expectations. The roof project, we were expecting to come in at about $800,000. The bids ranged from $790 to $826, one of the tightest bidding ranges we've ever seen, ever in a roof replacement, and right centered on our estimate. The parking lot, the asphalt work, we were expecting this to come in quite a bit higher because of all the news about availability of gas-related type materials and so on. And the bids ranged from 748 to 950 with our estimate at 800. We had another garage, not for a condo, but for a private landlord. And that was the widest range we saw of the bids that I selected. It ranged from 470 to 1 million with our expectation of being 750. We're still in the negotiation stage with the low bidder on that one because there is some uncertainty as to whether or not they can actually do the work. That looks like they just threw numbers at the page. So we might be going with the second high bidder there. So one of the myths that we had in our office was, could we even get this work out the door? And we managed to shatter that myth, and 4 out of, I think it was 17 total projects tendered. The reality is, yes, costs have gone up, especially on materials, but it looks like cost savings are being had by either more efficient labor forces or in one case, the labor force, the whole reason why the project was coming in under budget and on time was that the contractor said, hey, in these COVID times, I have to work with 2 crews, a morning crew and an afternoon crew. The total number of people on site was critical there because it was a very tight working space. And so they had 2 5-person crews working. And so they had 10 people on the job instead of 7, which would be their normal. So they actually gained the number of laborers by having 2 shifts. So some lessons learned from all of this chaos that, actually benefits owners. I don't know if any garage job ever benefits a condo owner because you get driven nuts by all the sound, but you can, realize some financial benefits at least. And I think that gets us back on time. Sonia, back to you.
All right, thanks, John. So some more good news, I guess, for condos is that it's not as bad as we were thinking it was. Okay, so another myth versus reality question. And we've got Blair Spinney, who is on our CCI board of directors and an auditor. And Blair, we know this happens, and although people may deny it, we do know this happens. When you borrow from your reserve fund, what actually happens when the audit takes place? So from an auditor's perspective, myth or reality of what happens at the audit time?
Thank you very much, Sonia. So I'm going to thank you very much for everyone for having me on your device. It's amazing I can actually fit into that your phone or tablet, because I don't think I can fit in much else these days. I actually did a little presentation. I'm going to try to see if I can share my screen. So let's see how this works. I think you have the right screen here. Are you actually looking?
We're looking at a blank screen with the CCI logo on
Okay,
top.
that's actually it. We're starting with a clean slate. Okay, so here we're going to talk a bit about, like Sonia said, borrowing from your reserve fund. Now I know this is a topic or an activity that happened even before COVID. But now, of course, the question's coming up with budgets being strained and whatnot. But can you borrow from your reserve fund? And I'm obviously speaking to that subject as an auditor. And what happens during the audit when you've borrowed from your reserve fund? So I'm going to start from the beginning and what's the auditor's sort of role here. So the auditor's role is kind of laid out in the Condominium Act, and Section 67.4 basically says the auditor shall include in the report. So by report, they're actually referring to the auditor's report that's actually attached to the financials that go to the unit owners. The statements that the auditor considers necessary if the corporation's financial statements are not in accordance with the requirements of this act and the regulations. So this really requires us to be, in a way, I guess, a bit of a whistleblower. Now, there are some auditors that do sort of contract out of this requirement. They will specifically put in their report that they are not they are not going to comment on the application of the Condominium Act. so they would not be fulfilling that role that's set out in the Act for the auditor. Okay, so let's keep going here. Uses of the reserve fund. A reserve fund, so everyone, this is also under the Act, and of course everyone's probably quite aware of what the Act says for the reserve fund. Shall be used solely for the purposes of major repair and replacement of the common element and assets. So we all know that one. And just to drive it home a little further, no part of a reserve fund shall be used except for the purposes basically above. So no, you can't really out and out borrow from the reserve fund. So that's taking money out of the reserve fund for operations or to be used in some other kind of fund. So next, another issue that comes up, well, what if I don't actually put it in the reserve fund? And there's a lot of more open interpretation here as to what that's all about. So section 115.4 basically says that anyone that receives money shall pay the money into a general fund or a general account or a reserve fund account. So you're required to deposit that money into the account. So that's pretty straightforward. Sample audit report. So here, this is actually taken straight from my own personal template. I don't put it in everyone's auditor's report because most people do follow the rules. So as required by 67.4 of the Condo Act, so that's 67.4 is right here. What's the auditor's role? It's to report on items that are not in accordance with the Act. And so we go back here. I'm in accordance with that. I'm reporting that the corporation hasn't deposited all the monies received from the owners to be allocated to the reserve fund. And so therefore it's not in accordance with section 115.4 of the Act, which is the one we just looked at. So that's what would go into the audit. If you've basically taken the money out of you've stopped making the payments to the reserve fund, and the year end goes by and you still haven't put it in. Okay, so the next sort of thing that comes up, well, what about sort of short-term loans? So in other words, what if I don't put the money in, but I put it in just before the year end? And what actually happens a lot of times, sometimes people will actually do, is put the money in just before the year end, and lo and behold, a week later, it's gone back out again, hoping the auditor won't notice. So now here you can do that. There's a lot of articles out there from law firms saying that you can defer paying the money into the reserve fund. So if we look back here, it says shall pay the money into the general account in the reserve fund. It doesn't say you have to do it the next day. So that means that you didn't put the money in, and you're just going to put it in just before the year end. So here you really got to think about whether you're not just complying with the Condominium Act, but do you really have a requirement for these funds that is more than just a short-term requirement? Like, is this a long-term operating issue, or is it a one-time thing? And will you come up with the money in the short term to pay for it? So if you are actually doing a series of loans and repayments, like putting it in just before the year end and taking it back out, you have to think about that the auditor actually considers substance over legal form. So maybe you are complying with the Act verbatim, but the auditor's duty is to look at the substance of the transaction rather than just the legal form of it. And if it's really a series of loan and repayments, it is really a de facto out-and-out loan. Also, the auditor's duty is to the unit owners. And at the end of the day, if it's something that I think that the unit owner should know, I'm going to put it in. And even if I have to say that, yes, It did go back, the money did go back in, but it's, in my opinion, it's a de facto loan. So the real solution to the issue is to have a hard look at the reality of the finances of the corporation. Why do you need the funds? And if it could mean that you could take a short-term loan, get by, and increase the fees next year. It may require special assessments if it's a one-time sort of thing, or you may even consider a loan. If it's generally not for operations, I wouldn't recommend that for operations, but a loan might be the solution to a short-term problem. So that's it, and I'll check the chat books for any questions, and I'll hand it back to Sonia.
Thanks, Blair. So I guess if it sounds like a duck, it is the duck, right? If you're borrowing, whether you're trying to be, creative about it, you're still borrowing, and we can't be doing that. And I think it's a good point that you raise, is that it actually highlights a bigger issue that the condo should be looking at. And also, for condos, don't forget that it's not just the auditor's report where the shortage in the reserve fund is going to be highlighted. If somebody requests a status certificate, it's also going to be highlighted there. So, think about that as well. Okay, well, that takes us to the end of our presentations today, and we do have time for some live questions, or if you don't want to ask them live, you can just put them into the chat box, and we'll read them for you and get answers. So I've got Margaret and Vince has had their hand up for quite a while. They've been very patient. So Margaret or Vince, do you want to ask your question?
I did ask, and it was answered. Thank you.
Okay, thanks. Anybody else have a question? Don't forget to raise your hand. You can do so by just pressing the raise hand button, or you can put it in the chat. And if you're on your phone, you can always press *9 and that'll raise your hand. So there's a couple questions that we got in advance that while we're waiting for people to ask questions, I'll put them out to the panel and see what they think about it. In terms of the elevator question, Raleigh, I was going to throw this to you. The ministry listed in their webinar a bunch of questions that you should be asking an elevator contractor before choosing someone for maintenance. And not everybody got to watch the webinar yet, although they'll be getting a link shortly. But is there anything else that the ministry may not have mentioned that you think would be something people should be looking at if they're looking to hire an elevator contractor?
Yeah, that's fair. I always suggest people just do a sanity test. They mentioned that there's 140 elevator contractors in Ontario, which would shock a lot of people. A lot of those are sort of 1, 2, 3-man operations, and so it's probably relevant. We're fairly small, but we have 20 technicians. So I think it's fair to ask, how many field technicians do you have? What services do you provide? If they do new installations, modernizations, repairs, maintenance, and their service areas from Toronto to Sudbury, they don't have an office staff dedicated, their warehouse might be out of the garage. Those are all, I think, relevant conversations to have with them, because you're likely going to get a lower initial price. But if you're wanting to make an apples-to-apples comparison, it's important. You've got a condo board, and somebody's stuck in the elevator in mid-February. You wouldn't be too excited to know that they're scattered across, the 4 technicians are scattered across the province. So they mentioned it in the presentation that lower price isn't necessarily the best choice, but sometimes it can be. And I think you need to have that conversation with your condo board. What sort of risk are you willing to take for savings up front? The other thing is some of these contracts have sort of hidden clauses. The lawyers on the phone will understand the ones that say the owner shall indemnify the elevator contractor. In plain language, that means you're accepting all liability. And that's huge. And for a smaller company, I'd like to have that in ours as well, because that reduces our potential liability. But it's important to the condo corp. So I would look at little things like that. Check out the clauses and find out more about the company that you're considering.
Thanks, Raleigh. On the question of electric vehicles, Laura, there was a question about how do you accommodate or prepare buildings for future growth with respect to electric vehicles and the changing demand for them as we go forward? Do you have any tips that you can share?
Sure. Yeah, I think it comes back to in my presentation when I was talking about starting by gauging demand and developing those policies early on. But I think the single most powerful tool that condo corps have to manage growth and demand for charging is load management. So the charging stations will be connected to the internet and talk to each other in real time and share capacity, and that way you can delay the need to upgrade your infrastructure.
Thanks, Laura. Patricia, I saw that in the chat box you made a comment in relation to one of Raleigh's comments about the elevator contracts themselves. Do you want to just share that with everyone?
Sure. That comment was, I attended that seminar and I thought it was very thorough, and it prompted some questions in my mind that when we're negotiating contracts with suppliers, we shouldn't be taking on undue risk for things that we shouldn't be responsible for in terms of, Raleigh brought up the indemnity. Indemnity should be narrow and tight, as well as insurance risk should be transferred back to suppliers, especially because we see insurance for condos to be in crisis. So we're looking to actually look at ways to reduce risk exposure through our contracts so they can be intelligently negotiated so they're balanced and fair.
Thanks, Patricia. There was an interesting question here. I know Michelle Farley's on the phone on the call as well, although she's not a speaker today. But Patricia, maybe keep your mic open, and Michelle, maybe you can join the conversation on this one. The question was, what would happen if there was a fire with injury or death in a condo and the board was aware of fire separation problems in the common elements between the units, but the board had not yet fixed the problem either due to COVID or not wanting to tackle entry into the unit issues, or not having funds to be able to take on that repair work? That's a pretty loaded question.
Yeah, that's like a case study. Holy smokes.
So, but it's a good one. So, Michelle, do you want to start? And then Patricia, you can chime in after.
Sure.
Yeah, I think you want the Reader's Digest version of my answer here.
we've only got like maybe 10 minutes left, so yeah, it's got to be Reader's.
It's okay. I can keep it pretty simple. Condominiums always have something going on. Whether you're tearing up tiles in the lobby or you're doing those types of repairs, there's often something going on. And obviously you do that as safely and as clearly as possible with lots of communication to everybody. Whenever there's a fire and we do investigations, and we're involved in several of them, we're looking for several things, whether the building was code compliant or not, whether they had the records or not, whether there was anything that impacted that fire. So tearing up your floors for doing carpeting might seem like a aesthetic issue, but if you have a fire during that and those carpets are torn up, were alternative measures made, were alternative exits planned, were residents notified? So the main thing is errors can happen, mistakes can happen. Sometimes somebody, may be impacted by some repairs in a building, but if it's a repair that the board knew about and didn't do, then there should be some pretty good paperwork showing that it was being evaluated and planned and there was an execution in place. Otherwise, you can be looking at liability. But the bigger liability I see from a fire code perspective is when doors are blocked off, or work is being done, or something crumbles and has to be fixed, and there isn't notification to the residents, signage posted for alternate options, people understanding what their options are during a fire. So definitely there's liability for anything ignored. The most important lesson is don't ignore it, make a plan, document it, and do everything you can to communicate that to your occupants and your owners.
Patricia?
Yeah, that was brilliant. And I totally agree with that. I think that, you want to make sure your insurance responds. So if you must immediately start looking at ways to address this in a reasonable time frame. The case law supports this, that where boards showed that they actually showed good intention, they were on it, they were getting there, they won't be penalized for that. So you want to make sure that there is an evidentiary record of acknowledgement you knew and that you're proactively addressing.
Yeah, I think there's a big difference between turning a blind eye for whatever reason, versus taking steps, but there's delays because there's other factors that are beyond your control.
Right. Exactly.
We definitely don't want to be turning blind eyes, not just for the sake of liability, but for the sake of the safety and lives of the people in our communities.
Right. And sometimes, boards can, balance cost versus safety. And that's the balance that the safety needs to win on that one. Right. So that is a clear threshold moving forward. It's driven by safety. Life safety is key.
For sure. All right, Blair, this question's coming to you. There was a question about when you said money must go into reserve or into general, what does the general account refer to? And you answered that part of it. You said it's the operating account, but the second part of that question says, the bank account of the corporation, an investment account, or can a general account simply hold dollars until needed within specific year or the next? Can you touch on that, Blair?
Okay, I guess the answer would be all of the above. Typically, you would put the money into your general account because most corporations do have electronic payments from the unit owners. So the money would automatically flow into the general account. After that point, you can make the decision, and after the money that, of course, has gone to the reserve fund, you can make the decision to take that amount or a lesser or a greater amount from your general operating account to an investment account that is outside of the reserve. In other words, an operating investment account. You can have an operating investment account as well. So the money could go there. There are restrictions there as well, but you could have that money go to a separate investment account as well.
All right, thanks. And Laura, there was a follow-up question in the chat box. The person asked, can you comment further on load management and what are the best steps to begin this and the steps that are involved?
Sure. So I think the two main types of load management are dynamic and static. So dynamic meaning that the charging stations can talk to each other in real time. And so let's say you have capacity for only 5 charging stations, but 10 are in use. Then when to make room for that 6th charging station, the 5th one needs to finish charging. Whereas with dynamic load management, all can be in use. They just reduce the output slightly to accommodate it. So I would just ask your service provider when you're procuring the technology, ask if the charging stations are capable of dynamic load management and if it's built in, if it's like built-in local load management, because you can make sure that those stations can accommodate that, and you don't necessarily need to enable it right up front. If they're network charging stations, they're just settings that you can enable as the demand grows. So they'll, as long as you have the capacity to support all of them at once, they can all be higher output. But then as you add more charging stations, you can enable the load management to kick in.
All right, thanks, Laura. And Cheryl, I think we'll pass the last question off to you. You did put an answer in the chat box, but I think it was a good question. I was trying to get to it. Do you want to just put the question out there about the PIC and then your answer with respect to that?
Yes. So I think the question was whether a motion can be made at an AGM to waive the requirement to send periodic information certificates. And it can be definitely be raised at the AGM, but the requirement under the Act, if a condominium corporation is going to waive the requirement, is 80% consent in writing. So you would have to collect the consent from the owners in writing to waive that requirement. And it's an annual requirement. You would have to do it each year. So when you obtain the consents, it's only for the current fiscal year.
Thanks, Cheryl. Well, I don't see any other hands raised. I think we've answered the questions in the chat box. So I think what we're going to do is we're going to wrap things up here. I want to start by thanking all of our speakers, Patricia, Raleigh, Laura, Cheryl, Tricia, John, and Blair. Thank you so much for joining us today and for catching us up on condo-related issues. I also want to thank our sponsors, and once again, thank you to Integrity Property Management, FCS Fire Consulting Services, Bayshore Property Management, and Common Ground Condo Law for supporting the webinar today. As I said before, and many times before today, without the generous support of our sponsors, we're not able to offer these webinars free of charge. So take some time and reach out to our sponsors and thank them personally. You can access their websites by going onto our website into the session and just linking by clicking on their logo. In terms of the recording for today's webinar, it should be available next week on our website. I just want to let everybody know about some upcoming events. CCI Haronia's next event in June, we are not having a Lunch and Learn webinar in June. We are going to try something new and something a little bit more fun. We're going to do an evening session on June 8th from 7 to 8:30. It's called Wine and Wisdom. This is going to be a really fun event. The details are going to be released next week, but there is going to be some wine. Optional drinking if you want. We do have Casey Farley, who's got lots of knowledge about wine, going to take us through some wine testing in CCI Haronia's own winery. And we're also going to have some breakout rooms where we're going to be able to interact with other people. So this is a real fun social event with a little bit of wisdom being shared. So please don't miss out on this event. It's going to be a great one. It is free of charge. Once again, thanks to our sponsors. And details will be on our website next week. In terms of other chapters in Ontario, the Golden Horseshoe chapter has a session coming up dealing with harassment in condos on May 18th. You can go to their website, cci-ghc.ca. The Grand River chapter on May 18th has their Level 200 Dispute Resolution CAT and CAO webinar, cci-grc.ca to register. CCI London on May 18th. May 18th is a busy day for CCI. Has their webinar, There Are No Stupid Questions, cci-sw.on.ca to register there. On May 20th, CCI Eastern Ontario has part 3 of their director's course. You can go to their website, cci-easternontario.ca. CCI Toronto is going to be talking about electric vehicles, and Laura, you're going to be at this webinar on May 19th. They're going to talk about electrical vehicle charging in condos, strategies and challenges. So if you have more questions about electrical vehicles, sign up for this webinar at the ccitoronto.org website. That's May 19th. And CCI Windsor is having a webinar on mental health and condo living on May 27th, cci-windsor.ca. And before we leave, I definitely want to make sure that people are aware that CCI National and the CCI National Conference is coming up on May 29th. It's a full day event. And we have a speaker, a keynote speaker coming in to talk about artificial intelligence in condos, which I think is going to be a really interesting topic. You can go to cci.ca to register, and I'm just going to share with you her introduction to what she's going to talk about, so you get a flavor of what you'll hear about if you sign up for the national conference.
AI has a real opportunity in the condo, strata, and townhouse environment. AI systems tend to take humans and human error and human effort out of functions and decision making. So maybe we use drones to understand roofs and the quality, or understand siding or bricks, and see if we can identify where there may be failures or cracks or issues that need to be addressed that may not be easy to identify by the human eye. Systems collect a lot of data, whether it's plumbing or heating or other types of environments where there's a lot of data and information collected. We can have tools and systems that identify where wear and tear might be happening and do some predictive and preventative maintenance. There's a lot of data that gets collected through board meetings and sharing of information. We can go and collect and analyze that data in a faster, more simple way by using some forms of AI. And last, even things like understanding behaviors and patterns of movements of people, and can we better improve heating and cooling and other types of systems. I'm going to talk about a couple of these examples so that you really understand how AI can be used and how you might want to be careful about using AI. So be sure to join me, cci.ca. Register for May 29th for the National Spring Conference, and I'll see you there.
So we hope to see everyone at the national conference. There are going to be people from across the country in terms of speakers and participants. So it's a great event, and I'm really excited to see what Jennifer's going to say. So until next time, I'm Sonia Hodes, and from the entire CCI family to yours, wishing you a great weekend. We hope to see you at the National Conference and definitely at our Wine and Wisdom webinar in June. Don't forget that CCI is your condo connection. Have a great weekend, everyone.